Okie dokie. Good morning, everybody, and welcome. Especially, actually, I think we're going to get going. People will join us. There were 23. Hello, Nicholas. Hope all is well up there in Pretoria. Today we're honored. Bruno, thank you so much for joining us. For some odd reason, the stupid thing is now doing captions for me, which is going to irritate me, but we'll just leave it alone. So good morning, everybody. Welcome, Bruno. Thank you so much for giving us your time this morning. Where the idea came from today's discussion was twofold. In the boot camp, you generously joined us and we spoke a little bit about rental mandates. And the issue that we were discussing there had to do with something that crops up often, where at the end of the fixed term, quite often landlords want to cancel the mandate. And then I get a call from agents saying, Sean, what can I do about it? So we sort of talked about that. And you came up with a lot of interesting ideas, which is why I wanted us to share that with the Rental Training Club, who are my fan base, I suppose, my regulars. We meet twice a month for an hour. And we try and do topical discussions, not just, the normal boring training stuff. So I'm very, very appreciative, as I'm sure they are, that you have joined us. I've made some notes. I'm not really going to stick to any presentation or anything. I'm just going to do a few little basics, just to make sure we're all on the same page. And then there's been a few, I call them case studies, where we learn from other people's situations. We try and avoid them ourselves. So Bruno, I'm just going to rattle into a few things, if you don't mind. And I just have to get the right presentation up here. And now I've got myself even one more box, but okay. So what we'll do is we're just going to talk about some very basic things to do with mandates. Some typical issues that I notice that still crop up, like mandatory disclosure forms, and those sort of things. And then I'll just say to you as and when we get there. Is that cool with you?
Yeah, I'm happy.
Fantastic. Thank you so much. So, ladies and gentlemen, what I'm suggesting we're going to try and cover today, and it's going to be very much, ladies and gentlemen, based on your questions. Bruno is here so we can pick his brain, which is certainly worth picking. So we now have the opportunity to get the answers from the experts. I'm just going to cover a few pre-mandate essentials and one or two very basic mandate basics, which I see people are still not necessarily doing, and that concerns me a little bit. We're then going to talk about this procurement versus managed. And these are just topics that I've put here, and I've got a case study that I've got on email. These are things that come up constantly. And so I thought we'd speak to Bruno. When we talked about procurement versus managed last time, Bruno came up with a whole lot of good ideas. Of course, I'm not sounding surprised about that. I expected that. Then we're going to talk about fixed term versus month to month. Is your mandate a fixed term or is it a month to month mandate? The landlord's right to cancel. This comes in where I get that question a lot after the first 12 months, that the landlord wants to cancel. What can I do? The agent's right to cancel. There's a very interesting case study that I have that we had earlier this month with one of my clients. Where I call it the case of the impossible landlord, but it is quite complicated. And then vetting responsibilities and expectations. And that came up from our brief chat yesterday, Bruno, where you said you're noticing a lot of things coming up. So I'd love you to share your experiences there, because that's one of the advantages of attorneys. You guys are dealing with all this litigation all the time. So it's almost like we can prepare ourselves for what is happening out there. So I put that in. And then my little hobby horse about payment of commission. Should it be on rent that has been received, or should it actually be on mandate, on lease rental amount? So without any further ado, let's get into it. Pre-mandate essentials. Ladies and gentlemen, there's two essentials that have to be fulfilled before you can enter into a mandate with your owners. Number one is the client has to be FICA. The FICA legislation, I feel a bit weird talking about legislation when we have an expert attorney on the line, but the FICA legislation says before you enter into a business relationship, or on the renewal, before you enter into a renewal of a business relationship, you have to FICA your clients. And remember, FICA these days does not just mean collect documentation. It's collect, verify, and do a risk assessment on the clients so that you know how to manage them forward. That's something that I know often people say to me, but the landlords don't want to give me the documents. Like, you've got to learn some skills and some scripts to be able to deal with that. Then, ladies and gentlemen, the mandatory disclosure form. I'm not going to go into this because I deal with this a lot when we deal with rental applications, but essentially in terms of the Property Practitioners Act, an agent may not accept a mandate unless they have been provided a mandatory disclosure form by the owner of the property. There's a lot of misconceptions, I think, still about this, given the questions that I often get. I just want to say briefly that the idea there is essentially that the landlord declares what they know about the property. It's not a trick questionnaire. It's simply what the owner knows. Now, I get a lot of comments like, no, but my owner lives overseas. He doesn't know his own property. Ladies and gentlemen, you don't have to go through the property. And Bruno, you will correct me if I'm wrong. It's not about going through the property and doing an inspection. It has to do with what the owner knows. So an owner will know if there was a roof leakage. Doesn't matter if he lived there, whether it was managed by another agent, whether his friends lived there, he will know if there was a roof leakage. He will know if there's subsidence at the property because somebody would have contacted him about it. So it all has to do with what the owner knows. So it's a matter of the owner simply stating and declaring and answering the set questions to the best of their knowledge. That's really all it's about. I've heard people say, no, well, I'll do it for the owner because I can go through the property. Ladies and gentlemen, please, please don't. The Property Practitioners Act is very clear. If we do not collect this disclosure form, okay, if we do not collect this disclosure form, and there's any claim from tenants in the future because of something that should have been declared and wasn't declared, then we, the agent, can be held personally liable for any potential damages. And I always remember the one story that TPN told. It was a sales story, but it works nicely, where the owner said they knew nothing about roof leaks, and there was a roof leak, and when they went into the roof, they found all these little buckies standing on the whatever those joists and things are called to catch the water. So it was proven that the owner did know about this. It had been a roof leak. So agents, please don't complete the mandatory disclosure form. Please get your landlords to do it. If the landlord lies on the form, you cannot be held liable. Then it's the landlord's endeavor. You don't want to get caught in this because, you know, I always think of the typical thing like black mold. There was a leak and there's muff in the house. And there's the, you know, somebody gets sick and blah, 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 blah. And potential consequences and liabilities and claims out of that. So I think that's important just to clarify. But those two things must be done before you accept the mandate.
Sorry, Sean, maybe just to step in there very, very quickly.
I was actually going to say to you now and ask you to step in, just to clarify, because you deal on the side where there's problems.
Sure. So just something very interesting. So a certain perception, and I think I might have mentioned this the last time that we were doing a talk together. So the problem is because of this legislation being relatively new. Obviously, there's not a lot of practical experiences that we can speak of. And remember, lawyers basically work off like experience shares. That's the reality. So when we go to court and a judge has it's an experience share, and we look at certain outcomes, and after a while, if there's more outcomes in a certain way than in other ways, that's how lawyers basically start adapting themselves to this is how the law is going to develop. What direction are we going? So looking at MDFs, the reality behind it is there is no clear exact science behind it yet, because this still needs to go to court. There needs to be like issues raised and that sort of thing. So two observations, call it gambles, call it predictions, right? Number one, what is the agent's position if the agent knows that the landlord is lying? So that's something to bear in mind. And I think that's where Sean is actually being very careful and advising you properly. Don't get involved, because as soon as you get involved, you're actually stepping into the arena. Then to step out of it and go, but I was independent, you're not, because you're actually involved as an agent. Almost plausible deniability to a certain degree. Don't get involved, because the more you know, the more it might hurt you, right? It's not necessary to speak about the best ethics. That's not a conversation about, but what's the right thing to do? What's the value add? How do you carry your business forward? This, for now, this is kind of risk management. Risk management dictates, don't step into the arena, because once you do, you're opening yourself up for attack. So step back and go, landlord, this is your responsibility, has nothing to do with me. That is the best risk management. Now, if the landlord lies, you know that he's lying. This is where I see a problem arising, because the legislation doesn't say that now ethically you're bound to do X, Y, and Z, but the way that it's being perceived and the way that it's being introduced, it treats it's property practitioners, it's professionals in all industries. If you look at accounting professionals and ethics, attorneys and ethics. I mean, I'm not saying all attorneys have ethics, but we've got rules of ethics that we should be following, right? Doctors. And the reality behind professionals is it's not about the specific wording, it's about how you act. So if you know that somebody's lying, an attorney cannot put a witness in a chair and ask them a question knowing that they're going to lie, because then the attorney's guilty. So if you introduce an MDF to your tenant, knowing that the landlord lied, be very, very careful, because I'm willing to wager that this responsibility is going to fall on you. And then just a second observation, the upside is rental agents, I do still feel, aren't as deeply impacted by this as sales agents, because the seriousness or the permanence of the MDF isn't as much. So a person buys a property and there's a massive issue, they're stuck with it, and they're paying a 20,000 Rand bond per month on a property that now they can't live in, or that's whatever, it's falling apart. With tenancy, not really, it's a defect. The guy didn't disclose it, cancel it, find a property down the street, you're inconvenienced max a month or two. So just bear in mind as well. So that's not to say like chill, relax, don't worry about it. But you know, do breathe a kind of sigh of relief that you're not in as much or you don't have as much pressure as a sales agent.
Yeah. And I mean, in a sense, we have longer term relationships with our clients, but then again, a sale, the buyer has a longer term relationship with a house. Exactly. So I agree with you, and the financial impact there, because you're talking about the value of a whole house. But I'm thinking of typically things like mold, okay, where, and it's the only real example I can come up with where a tenant can get very sick or something like that and then start claiming things. To me, it's just important to that people must remember they mustn't fill it in. As soon as we fill it in, well, point number one, the law says the landlord must. So we're not fulfilling the requirements of the act. But secondly, as soon as we fill it in, we actually don't have the information, because if this is a new landlord, and this will come because it says we have to do it before we enter into a mandate. So it will generally be a new landlord we're dealing with. We don't know what's happened to that house in the last 10 years that the landlord's owned it. So we're not actually empowered with the knowledge to fill it in. And this does get passed on to the tenant, because we have to give it to anybody that wants to put in an offer. And I have it worked into my application process where we send it out as part of the process. But I do notice that people still think, oh, we must get an inspector in, or I'll do it for the landlord and that sort of thing. And that worries me. So it's my worry and my concern of trying to help people. I have this saying, which I hope you don't find offensive, but it's cover your ass. So I'm always like, cover your ass. And I've realized that rental agents have two, well, everybody's got two butt cheeks, but we've got two, because the tenant slaps the one and the landlord slaps the other. So this is just part of my CYA. Being very cautious, trying to prevent the preventable issues. So just quickly with the FICA and the mandatory disclosure form. It's before we accept a mandate. And FICA is definitely with a renewal of an ongoing business relationship. So the renewal of a mandate, the mandatory disclosure form. If I get a mandate from a landlord now, and that mandate, oh, well, we'll talk about that just now, actually. But that mandate comes to an end, and I then have to get a new mandate. That will also be a new mandatory disclosure form.
Yes, because it's on the provision of a mandate.
Yeah.
So strictly speaking, each instruction would comprise its own mandate.
Okay, thanks for that. So now just a few little basics. And sometimes I think that everybody just thinks of mandate is just this thing I've just got to get done quickly because the boss says I must do it. But there's actually some incredibly important reasons that we need to do this. And so I'm just going back to very, very basics here. Point number one, what is a mandate and what is the benefit for you? And if you go into the Property Practitioner Act regulations, they give a nice definition there. A mandate is an instruction or an authority given to and accepted by the property practitioner to render a service. So it's where the landlord tells you what you must do or you agree on what you must do. But it's also the thing that gives you the authority, gives you the permission to act in your doing of your day-to-day stuff. So it may, for example, say that you are authorized to do the credit checks. Okay, argument's sake, I'm just using a simple example. But it will not, it probably will not say, and I hope it doesn't say, that you are authorized to sign the lease agreement. So because the mandate doesn't give you the authority of the owner to do this, so that's where it becomes so important, because it empowers you. And if it doesn't empower you, if your mandate doesn't say that you are entitled and have the owner's authority to do this specific task, then you don't have the authority to do it. And that's very important. It's our authority instrument. And I love the way they say that given to and accepted by a property practitioner. Most of the time, I think we feel like we're begging for it, but it's once again a simple contract thing. The landlord makes an offer to you. It's a standard offer generally based on your service offering, but you accept it. And once you accept it, you have the obligations to fulfill out of that mandate, and both people do. Just the second one there. This links up with the Rental Housing Act, where the Rental Housing Act talks about landlord-tenant, landlord-tenant, landlord-tenant. And some agents say to me, but it doesn't say agent. No, but it does. Because if you go into the definition of landlord, it says that it's the owner of a dwelling which is leased and includes his or her duly authorized agent. And that authorized is this thing called the mandate. So those two things go hand in hand. It's the thing that authorizes you to do what needs to be done in terms of the mandate. I don't know if you want to comment on any of that, Bruno.
Actually, yes, if you don't mind. For starters, one of the questions
we are here to pick your brain. I do not mind. I'm wanting you to talk.
So one of the questions that they actually asked now touches on exactly what you spoke about, and I think it might merit actually moving away from a discussion just on legislation just for a second. So my background is in commercial, right? So I've always worked in the commercial space. So my clients are property investors who invest in property. So what did we do? We solved their property related problems, but they were making money from it, right? My conveyancing is all about doing things in a certain way, optimize businesses, entrepreneurs, property investors, developers, that sort of thing. So we've always had a different mindset, not to say that conveyancers don't have this mindset, some do, but we've never looked at things just as here's a conveyancing process, it's linear, it starts here, it goes through to here, right? And that's kind of their scope of focus. We've always had to work around this box to make sure that things in the box fit. Now, why this is relevant is when, especially if you listen to a lot of PPRA talks, right? You get this a lot. They bring the property practitioners and estate agents profession into this box of you're a professional, this is a mandate. What's a mandate? And it's perfectly defined. And Sean, to the T, defined it. But he also mentioned one thing that's very crucial It's that element of agreement. So if we step away and we look at the general applications of contract, and let's just think contract, and we start working with each other and forget estate agents, forget labels. If we start working with each other, and there's nothing that underlies these principles, because I think that's where we lose a lot of our ability to be creative, is a lot of these principles are already sub-defined, and we kind of tend to stick with them, and we restrict ourselves on what we can achieve. And that's the conversation today, is how should mandates be looked at? Everyone assumes that the mandate's predefined. A mandate can only say certain things. No, a mandate should say those things, but it's not limited to those things. So we need to be clear on what the fundamentals of mandate are, what they have to have. So as Sean pointed out, yes, they need to have that authority, because to a certain degree, you have to market the property on behalf of the owner. Absolutely. But you don't sign the lease on behalf of the owner. So it's almost like having a little bit of a power of attorney. You act as agent, you're appointed as an agent for a specific task. That's a fundamental. Another fundamental, for example, is what are you earning for this particular service, right? This is fundamental. So mandate, in fact, a mandate doesn't even have to have a price, in fairness. A mandate, by definition, law is you go do this, go do it. You don't have to pay someone for a mandate. Obviously, a mandate within our sense carries a fee, but this is where we need to start understanding. All we're doing is contracting. And as we start looking at it, stop putting yourselves in this box of estate agents, basic mandate. This is actually all we need in order to move forward. You're running a business. And this business means that you need to be smart about how you word your mandate to be able to achieve certain outcomes, right? Get those results, get those payments, but also manage your clients' expectations. And all of this is lost with agents, well, not agents in general, but all of this is lost on some agents. And that's why some landlords jump around, because those expectations aren't managed. And I suppose that's what we're going to get to now. But as the introduction of mandate, it's both an authority, but that agreement component is really so key. And that's where you can start being creative.
Ladies and gentlemen, I'm going to get your questions now. Some of them fit in with topics that we're going to be touching on specifically. I'm not ignoring them, just so that you know. My simple summary of a mandate is it needs to say who needs to do what by when.
Yeah.
So that you can measure it. So do what means what permissions do I have? What does the landlord have to do? By when does the landlord have to do that? And so to me, there's those that should really be covered in the mandate. And one of the things that I want to make a comment on is that there are mandate templates available out there. And I'm using the word template very, very on purpose here. Because in the end, those templates, because of the nature of them being made available and having the legalities in them, are general. An agency should take that template and fine-tune it to its own service offering. You know, when are you going to pay the rent, blah, 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 when do you do your LODs? I believe all of those things should be in there, because then you are giving the landlord, your client, the peace of mind that I am committing to this. And that's really what we are doing. If I look at the basic templates, to me, they are there as sort of a template to work from, but they're not specific enough. And I know why they're not specific enough, because everybody does things differently. But I find a lot of people are just taking those templates and using them. And then they will say to me, but what about this? And I'll say, go back to your mandate. What does it say? And they say, oh, I don't know. We've got to understand our mandates, because only then do we know what our obligations are and what our contractual responsibilities are. Oh, how did I get here? I've done that already. Okay, so I'm going to now take one of the questions here. When landlords, Bruno, are in another province, this relates to the mandatory disclosure disclosure form, MDF as you call it, which I thought was a wood paneling, but okay. When landlords are in another province, can the person that works on the building permanently in charge of maintenance complete the declaration?
So I was actually going to touch on that previously, and then I completely forgot. I went on a tangent. So the whole point of mandates and agency is exactly that. Representatives, so people that are authorized. So think of companies, for example. A company in itself is not it's a person, it's a legal entity, but the signatory is a representative, right? So it's similar to any sort of relationship. So a landlord can have a person that represents them. What you mentioned correctly, so is don't let that be the agent, because don't step into that arena, like stay out of it. That we're giving you professional advice. But if the building maintenance person is actually mandated by that landlord to take care of the property, they're in the best position to disclose the issues with the property, and they have themselves a mandate or a power of attorney or some kind of authority or resolution to act on behalf of the landlord. That's no issue at all. But they need to have that. They need to be duly authorized. And the term duly means properly. So don't just accept it and go, yeah, but I know more than him. That's not duly. Duly is when they've actually signed something saying this person is authorized to sign this on my behalf. Then you can accept it as an agent that the landlord has given you a valid and compliant MDF.
And I think one's got to be careful if one's looking at buildings, okay, where one owner owns the building and he's got a maintenance manager. Different, that's one scenario. But the majority of our clients work in the residential sector with single landlords, with single properties, or maybe multiple properties. But the landlord doesn't have one contractor that looks after the whole house. We call in a plumber, we call in a this, we call in a that. And in the end, the Act does say the owner must complete. So I'm assuming that if we get a situation like you sketch now, the best thing would be to say, if somebody else is going to complete it, Mr. and Mrs. Landlord, I want a copy of the authority to attach to it. Once again, to cover my butt.
Absolutely.
Okay.
Absolutely.
Yeah. Then another question, and just so that you know, if people send me direct messages, my arrangement is that I don't mention names publicly. Instead of asking the landlord to sign the 6-page mandate each time, can we do a 1-page renewal, such as, i.e., renewing on all on the same basis, but signing on but a different rental amount, or be more creative?
I don't, sorry, I just had to put my head.
I don't see any issue with that at all. So remember, again, when we look at the law of contracts, there's a fundamental agreement that everyone agrees exists. So if we're now changing some of the terms and we're asking for a higher rental on a specific property, we're paying a higher commission, lower commission, procurement fee, management fee, whatever the case is, you can very easily just have a little addendum that says, you know, that agreement there, it's 100%, it's still in place, we're renewing it. Only difference is we're adding clause A, B, and C, or replacing A, B, and C. But that's absolutely fine. There's no issue with that at all.
Yeah, but this is a CYA matter, cover your behind matter, because of the fact that, and a lot of people don't realize this, is that the rental amount you can advertise for is one of your mandated facts. In other words, the landlord saying, I want you to advertise for 10,000 Rand. And then later on, you might need to change that. And it's always, and I always say to people, get everything in writing. Even if all you do is say, is write an email to the landlord after a phone conversation, say, as per our phone conversation, we will be reducing it to blah, blah, blah. Because to me, that's enough documentation to you know, I don't hear of issues happening, but cover my behind. I don't want to have unnecessary issues. Issues don't pay money.
And but the risk. So I had a case like this recently with a rental agent, and here's where we need to worry. So there are two little observations. So the first one's a basic one. If your mandate, for example, happens to have a clause in there that this mandate can in no way be varied unless in writing and signed by the parties, a person could potentially have an issue with a single email or something along those lines, or a WhatsApp message. So be careful, because if your mandate doesn't allow certain variations, whatever, so you can set it up to go, you know what, I do want to vary over email. Or as an agent, you could go, I don't, because some landlords confuse me over email. There's a thread of 500 messages and they say this here. I've got no idea what they're talking about. The last thing you want is them to rely on that and say, but I told you in email number 20 that you should do this. So you as an agent need to manage your own processes. Do you want the flexibility to vary, or do you want the rigidity of not getting confused by landlords like miscommunications? Yeah, so that's the first thing. But the case that I dealt with recently, and this is telling, and it's all about this. So the landlord, long story short, the agent found a tenant. The agent introduced the tenant, vetted the tenant up to a certain degree, which is why I wanted to have the vetting conversation later. So to a certain extent, he vetted. He supplied the landlord with the information. Now, the problem is with the communication with the landlord, look, I'm not saying the agent was right. If I was the agent, I wouldn't have allowed the tenant to take occupation. But unfortunately, in the communications with the landlord, there was emails and WhatsApps. It gave almost this a tacit consent that, like, yeah, it's fine. Let them move in. Just do this. But it was tacit. It wasn't expressed. They didn't say it in those exact words, like let him move in. I think he just said, I'm happy, or something along those lines. It looks good. I think it was like, oh, it looks good. So the tenant let him move in. Then a few days later, the landlord comes back and says, look, so I had a look. This document over here, I see that you haven't done this. This is a bit of a problem. I'm not comfortable with this. And the agent went back and said, oh, but now he's moved in. And the landlord went, no, I never said he could move in. And now the argument is about it looks good, and whether it looks good is a proper instruction in terms of that mandate to allow someone to take occupation of the property. And because that mandate was verbal, no one can actually even go to it and say, oh, I accepted that this was approval. In fairness, this wouldn't have stuck even if there was a written mandate, because it looks good. Wouldn't have never worked. But at least in your mandate, if you've got a process going, I will only let the tenant move in. Because imagine if it was the flip side. Imagine if the landlord went, it looks good. And the tenant waited and went, okay, it looks good, but that's not an approval. I'm waiting for him to approve. Now, the agent needs to be able to know that there's that specific process. Landlord, that's not an approval. That's not enough for me to actually stick the person inside. Long story short, now this agent's in trouble. Landlord wants the tenants out. He can't get the tenants out, had to give up his procurement fee, and I was trying to get the tenants out. And yeah, and it's a disaster. It's a complete nightmare. So just be careful, guys. Your mandate can actually regulate this if you use it properly. I think you're on mute, Sean.
You're right, I am, because I go, and then I realized I take your sound away. So I decided the way to do that was to mute myself. But I'm not used to muting myself. I have a very strict, legally compliant and best practice rental application process that I go through, where we have a formal report we give to the landlord, and we require them to come back to us in writing to approve it. And we then get the lease done and we get the deposit paid, because I believe until the deposit is paid, I will not even prepare the lease agreement. Okay, because that deposit is the only surety for the landlord. So I am presenting that tomorrow. For those of you who haven't done that, I have just advertised on Facebook and I've sent it out to the database. So I am following that tomorrow, because that to me is a critical thing. Too many things go wrong. Too many times when the agent calls me and asks me a question, and then I'll be like, but what does your lease say? And send me your lease. I don't know what your lease says. And then they send me a lease and it's unsigned normally by the landlord. I think we've got to, if we want to be professional and want to charge professional fees, we've got to act professionally and do our jobs properly. So I think that's part of it. But yeah, I am rather anally retentive with these things. The next topic I'm going to seg into is this matter of procurement versus managed. Okay. And specifically, when does procurement end? That's the one thing. The other question that comes up a lot here is that the landlord chooses managed, and I have a client who's on the line who has this situation. They choose managed because they don't want to pay the procurement fee. A few months into, they then cancel because that's now the cheaper way of them getting a tenant. And the other thing that I just wanted to bring up, and okay, maybe we should deal with these one at a time. I'll get into this one now. So procurements end. When does that end?
Sure. Look, so when I speak about procurement, and especially if you look at it from two different hats. So if I came to you and said, please get me a tenant, what do? You go to market, you put out an application, take photos, put it out there, get interest, show the person the property. Depends on the extent of your procurement mandate. Are you just going to introduce them to me, or are you actually going to do viewings? That depends on the model. Your preferentials and your house me's versus your normal agencies. But let's say you do the viewings, then it comes to vetting. Are you also responsible for vetting? Maybe, maybe not. If so, there's a vetting process. You give me the information, I make the decision, I instruct you. Procurement can even include preparing the lease agreement, typically would, because that normally defines the end of the process, because now there's a lease, it's signed, deposit gets paid obviously before the lease is signed or after the lease, whatever the case is, and the person moves into the property, consider it procured. And that's it. You've done your job. And the landlord can now actually do everything himself. There's no need for you to hang around. It's done.
Importantly, the contract is then at an end. As soon as you have fulfilled your responsibilities and the landlord has fulfilled their responsibility of paying you,
yes,
that contract is at an end. There's no more contractual relationship. No. It ends.
No, unless you lied. So it ends, it's discharged. Obviously, the only lingering provisions are if you lied or did something reckless, yes, or negligent, didn't do the due diligence to the extent that you were supposed to. So there's obviously you can't, yeah, but you know what I mean. So it's discharged unless.
The reason I bring this up is because there's often situations where somebody is contracted to procure. I mean, your mandate obviously have to say up until what point. Ingoing inspection, I would normally include in a procurement, but it's the inspection report. I will not get involved in the outgoing inspection if it's a procurement, because I know nothing about what happened, and what they're trying to do is involve me in their arguments at the end. And I ain't falling for that. I ain't working for free.
Yeah.
So that's the important thing. It comes to an end. But then let's say you've placed somebody and 3 months down the line, they exercise their right under the Consumer Protection Act to cancel the lease early. Now the landlord says, wait, but that tenant didn't stay. You've got to now find me another tenant for free. Your thoughts on that?
Yeah, so and I think this is my concern with practice is, in situations like this, people always try to default to what industry norms is. And you see this a lot, like, for example, with sales, where there's a mandate, but no one actually speaks about it. They find a purchaser. Some agents will actually take a purchaser directly to a seller, and then after the fact, they try and negotiate fees. But they, to a certain extent, people resort to the default position of, well, the range of fees are normally between this amount and this amount, right? And this is what the industry dictates. This is what's allowable in terms of the PPRA. The problem with mandates is there's no real norm. There's no comfortable sensation of this will apply unless otherwise stated. And that's where my worry comes in, is what is the norm? Some people charge procurement fees, some people don't. Some people work them into a management fee, some people don't. And I worry about some of the agents' mandates where the procurement fee is simply scratched out and there's a management fee. What does that mean? That means that you're not charging a procurement fee. You're not charging. You've scratched it out. You've given it for free. It's the equivalent of you doing a service and saying, don't worry, it's pro bono. And that's the concern that I have. You don't actually say in the mandate that this zero is subject to this. And if this doesn't transpire, let's say a 12-month fixed lease agreement or whatever the case is, we will default back to this position where you owe me a procurement fee. So my sensation on this is we probably need to have a good conversation about, from beginning to end, what the best business model, what different business models people use in the space. So you have the guys that do charge procurement fees. You're safe. You've done your job. You got paid for it. Now you put on a different hat. You do management. No real issue there. You make provision for both. As soon as you start tying the two together as a business proposition, I would say you need to step in and be very careful. What are you trying to achieve? I'm giving it for free because I know after a period of time, I'm going to make my money back through the management fee. It's more valuable for me to manage for 12 months than it is for me to charge a procurement fee upfront. Maybe it's because the market's saturated and no one charges it. Maybe it is more valuable monetary wise. I don't know. But whatever that is, needs to be specified. And now, sure, if there's an early termination, what happens? Because that's not the landlord's fault. So shame, poor landlord. Now he's going, yes, I know, I agree, 12 months, but that's not my fault. The guy terminated early. What can you do? Can you factor that into the cancellation penalties? Maybe it's something to look into, because it is reasonable, because the landlord is actually suffering prejudice. So he's suffering prejudice because he had a 12-month lease that ended on month 3. So it's going to take him a month or 2 to find a new tenant. So maybe there's a cancellation penalty for those 2 months. But the reality is he actually needs to pay the agent now a fee for finding this new tenant. So in commercial leases, this is how it works. You cancel early, 100%, but you need to pay the amount of time it takes you to find a tenant plus the cost of acquiring a new tenant, and that is paid by the it's normally paid by the person breaching the contract, but the landlord would pay but claim it from the tenant. So you could claim it from the tenant as a reasonable cancellation penalty, as an example. So that's an early termination. But if it's landlord termination, there, my argument is, landlord, you're not actually allowed to. There's a fixed term period. If you do, we either revert back and you pay me that procurement, or I say, sorry, no, you can't cancel. And if you really want to cancel, no worries. Just pay me the rest of the contract period.
One of the things we discussed in the boot camp session was that if somebody's management is structured such that there's no upfront procurement fee or small upfront procurement fee, a placement fee, let's call it a placement fee, not a procurement fee, and then an ongoing management fee, one could have different ideas where, for example, they may say that if the tenant cancels within the first 3 months, we will replace the tenant for you for free as a marketing, and you came up with this, which I thought was a very clever marketing proposal. We give you a 3-month guarantee sort of thing that one has to work. But should it happen after that, one needs potentially, it's a good idea, once again, your thought, to have a clause in the mandate that says, if you can cancel the management earlier than the 12 months or whatever it is, the mandate, sorry, earlier, it will revert to a procurement mandate, and a full procurement fee applicable to the lease will be effective. Those were 2 sort of thoughts, because you put your lawyer's hat on and talked about how lawyers worked and how we don't work for free and all that sort of stuff. And I thought those were really, really useful.
And it's in the recruitment space. So I got that idea because if you go to recruiters, they will always, so they charge quite a bit. So this is also the thing, they make their money up, and maybe agents need to put their hats on and say, we offer a guarantee. No one else offers a guarantee. They'll give you tenants, but you don't know what you're getting. Now we will vet these tenants, we will question them, we'll interview them, whatever you want to offer, do that value add and charge a decent fee, charge a proper high fee, but then offer a guarantee. And imagine having a landlord that goes, okay, wow, but they almost promising that these guys will stay for 3 months or will pay for 3 months or whatever the case is. So these are all value propositions, because in the recruitment space, they charge you 15% of an annual salary. But if the person resigns or you don't like them and you let them go before 3 months over probation, they will find somebody else. But that's because they're making 15% of an annual salary. So agents obviously need to look at this model and go, well, okay, I'm not making that much, so I definitely don't want to guarantee rent for 3 months because that might take me under. But I can maybe offer to find somebody else at no charge. And that's something, yeah, that's something to evaluate.
And it could become your unique selling proposition, your USP, because I think one thing, and I noticed that often the feeling is, and when I was managing, I used to have the same thing. The agents would say, but I can't charge this because the one down the road charges that, you know, so we have to meet them. In other words, we all got to go down. And I used to say, but no, if you can sell your value to the landlord, the mandate should never be the first time you talk to your landlord. You've got a process, you get there and you sell your value to the landlord. And this could be one of those things that set you apart. We give you a guarantee that we will replace the tenant. We're not responsible for their debts and all that stuff. I mean, seriously, we can't take on responsibilities for adults.
Sure.
But we do something like that. That could be a very good marketing proposition in a market to stand out.
Absolutely. Absolutely.
Because landlords in the end are worried about costs. And so it gives them that peace of mind. Now, the other matter I want to talk about, and this has to do with, it's really the next topic, but I put it in here by mistake. The fixed term mandate versus the month-to-month mandate. Now, a lot of mandates say something like this, where it says, should it's specifically recorded that blah, 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 should the tenants, so they operate under procurement or management mandate, should the tenant renew the lease agreement or conclude a further lease agreement after the termination or cancellation of the lease agreement with or without the assistance of the property practitioner, then the property practitioner will be regarded as the effective cause of the conclusion of the renewal or further lease agreement, and they will be entitled to payment of commission by the landlord. So this will typically be where at the end of the 12-month period, the landlord says, you know what, this tenant is so good, I'm going to look after them myself. Now, I'm just going to make a quick comment there, because one of my philosophies is, if they think this has been easy, then it means we haven't kept them up to date. And I believe that's how we show our value. We communicate a lot. They must know what we're doing behind the scenes because we're making it look easy.
Sure.
But how do you feel about this clause?
Look, so again, because it's part of the agreement, it sticks. So if the agent wants to try and enforce that and the landlord doesn't have any objection to it, why not? Would it stand in the market? Would normal landlords want to sign this mandate with this clause in there? Obviously, that's something to be determined. The reality here is we're procuring a tenant, possibly managing the tenant up to a fixed term period that concludes. And now the landlord says, great, I'm on my own. You've done your job. You've procured the tenant. Thank you very much. I've paid you for that. Or it's been worked into the management fee, which you agreed, which was 12 months. And on top of that, we've paid you for your 12 months. Theoretically speaking, effective cause or not, if the mandate doesn't specify that you're allowed to charge a second procurement fee, then you wouldn't be allowed to charge a second procurement fee. I like the idea of the clause because the reality behind it is the landlord would have to find a new tenant. So potentially he would have had to pay a procurement fee. So now you're responsible for year 2 as well. But again, it's all contractual. I would probably argue that without it being specified in the mandate, it wouldn't be so clear cut.
Yeah, I also have a comment that I'm going to make on this, and that is like that matter of getting the money out of the landlord. The landlord cancels their contract, okay? Now they go and sign their own lease. We say we're the effective cause. We now bill them. I don't have that, you know, sometimes it just has to do with practicalities too. I don't hold a landlord deposit in my for a mandate. I can't grab any money. So in the end, it's either, I believe you're going to be very lucky if they pay without complaint. I believe, just in a practical, my experience. And then it's a matter of, do you pursue them or not? And somehow I think that's not good business practice. I might be wrong. But
so obviously, yeah. And obviously it comes down to exactly that. So are we having a conversation over the 12-month management mandate coming to an end and the landlord simply wanting to retain the tenant? Because that's one conversation. If we're having a conversation about the landlord terminating the mandate with you earlier, it's a different conversation, obviously.
Sorry, I'm talking about the 12-month mandate comes to an end because the lease was 12 months. And the landlord now says, don't worry, I'm going to look after the tenant myself and do my own renewal. This clause seems to address that specific circumstance where it says that if the landlord does their own renewal without our intervention, we are seen to be the effective cause of that, and we're entitled to that fee. To me, the practicalities, I mean, it's all good and well writing and in paper. The practicality is getting that money out of the landlord.
Yeah, absolutely. Absolutely.
Okay, so now, now I'm coming to my fixed term versus month to month. Mandates often, and I think this is once again just the way things have worked, and because there's less paperwork, run concurrently with leases and any renewals of the lease. So it will say under a management mandate, this is just a clause out of a typical mandate. Under a management mandate, this mandate agreement will continue for the period of the lease agreement or any further period that the lease is renewed. It will then continue on a month-to-month basis after its termination. I think they mean the termination of the lease agreement or the end of the fixed term. The wording's not so lacking. Now, if I have a mandate, my mandate is not fixed term as such, but my mandate has this clause in it. I then enter into, I authorize and I prepare, and if the landlord's done everything right, we now enter into a 12-month lease agreement, fixed term. Does that mean that my mandate has now become a fixed term mandate because of this clause?
It's a determinable time period.
Okay, so now we've got a 12-month mandate where we are the supplier, the landlord is the consumer. Fixed term, end of fixed term lease agreements, we now go into Consumer Protection Act, which means that the landlord at any point in time, as the consumer, can give 20 business days notice as per a lease agreement to cancel this mandate, but we could potentially charge a cancellation penalty.
Sure.
Okay, and I think that's important because a lot of us don't think of that. We think that, because it's running concurrently to the lease, this is a month-to-month thing. But this is where the cancellation penalty could come in. So I think something that's not often addressed in mandates, and I couldn't find it in the specific mandate I was going through to grab these pieces, is no detail on what the cancellation penalty is or how it can be calculated.
And it's quite unfortunate because it's going to come down to facts and the way things are worded. So remember, a reasonable cancellation penalty is premised on what prejudice and damages you could potentially be suffering. So you look at the remaining period of the contract, but you also bear in mind that remaining period of the contract less the work that you're now not going to have to do. And you try to put a value to that. So what would be reasonable? 3 months, 3 months is an example, because I'm not actually going to need to perform any service. So that's a win. The loss is I'm not going to be able to make any profit. So you try and come up with a figure. It is, for the most part, thumbsucked. But that's why I also think that reverting to the procurement fee makes sense. Have a higher procurement fee, because then the argument is, I worked in the procurement fee. That took a lot of effort. I worked it in here. My cancellation penalty is actually pay me the procurement fee, or make it a term of the contract. You pay me the procurement fee plus this, because that will at least then justify that you have performed a service. There's an actual fee associated with that service. So forget that I'm not going to be managing on a month-to-month basis. I've already done what I wanted to do. Pay me for that. So I would always suggest revert back, because it's better to justify a service that you've already given and not charged for than justify getting a fee for a service that you're not going to provide.
I agree. Now, I know Bruno's got to jump out just before 10 because he's got another appointment. Bruno thought didn't understand that we can do Q&A for an hour. You see, we still got 20 people. We keep it exciting.
It's incredible. Incredible.
I do want to go to this specific case study because I don't want to miss this one.
Sure.
It's one I dealt with earlier this month. I call it the case of the impossible landlord. The landlord signed a mandate with a rental agent working for a rental agency. The rental agent found a suitable tenant approved by the landlord. before the agent could send the lease and supporting documents to the office, the agent passed away. This is a real situation. The office was not aware of the property or the mandate, because it's one of those offices where people are geographically spread, as it had not yet been sent to the office before the agent passed away and deceased. The landlord started phoning other agents within the company because she couldn't get hold of the agent. The agent referred her to the office, the agents rather. Then the office got a call from the landlord, wanted to know if the rental money is in on the 25th of the month prior to the start of the lease. Rental money wasn't in. They got the lease from the landlord, phoned the tenant. The tenant was not, this is so complicated, was not moving in because they were in a vehicle accident and they were in hospital. Okay. The tenant was then fortunately advised to give 20 business days notice because there was a lease, blah, blah, blah. They explained to the landlord there's a deposit that they can use the deposit to offset the first month's rent, but only at the end of the 20 business days or when the replacement tenant is found, whichever comes first. Landlord, I'm reading from the email, goes ballistic. Insists she wants compensation for the inconvenience, bank charges, still not sure which bank charges they're talking about, insults office staff, insults the agent who took over the deceased agent rentals, insults the principal, shouts and screams with every phone call, and does not give anyone a chance to explain or answer. She just talks over you. Wants us to sue the tenant's mother for rent for the full rental period, as she's also a signatory on the lease, etc., etc. Then she said she's going to cancel the mandate. And this was the one thing I grabbed onto. So we accepted the cancellation in writing. She then asked the way forward 8 days after cancelling the mandate. Can you believe? Basically fires us. Then I explained that she will need to urgently appoint a new agent, must advertise the property immediately and consult with us regarding the cancellation penalty. Any learning out of that?
Okay, so the first thing I'd always suggest, and I think this is a trick of the trade, is separate the issues, because there's obviously a lot of emotion here, frustration. I mean, the fact that it's the impossible landlord already like creates this undertone, which is problematic. So let's look at it almost completely impartial. So the story I hear is that a agent received a mandate. He found a tenant, he introduced the tenant, both parties signed the lease, so there was a binding lease agreement, and he was going to send it to the office just for recording's sake, but the reality is it was in place, right? And he was going to send it to the office. So that was the procurement side, whatever the part of the mandate. Then there was the management component. So the agency who took the mandate theoretically had an obligation to now manage. He didn't send it to the office, rather, sorry, and he passed away. That is unfortunate, right? Does it excuse an obligation by a business to perform its functions? Unfortunately not, because remember, it's strictly speaking, the mandate says you have to do X, Y, and Z. If you don't do it, unfortunately, unless there's like a vis major or something along those lines, typically the agency is still responsible. The processes should have been in place that irrespective of somebody's death, things would continue to happen. As a result of this, one does need to bear in mind that the landlord could potentially have suffered damages but now it also depends. Did this tenant say or do something before they had to move in? For example, to say, oh, we're not moving in. Or did they give the notice and no one picked it up? Because now, yes, the agent was supposed to manage, but the tenant, on the other hand, also messed up over here because they let the period run. Their taking of occupation doesn't impact their liability in terms of the lease. And yes, although some leases requires a term, the tenants have to move in. The reality is if they don't, they're still liable for rent. So in my mind, I'm thinking, could the agent, had he been alive, could the agent have picked up and done something about this? And how much time would he have saved? And that difference in time could potentially be a risk, potentially. But the tenant, on the other hand, did the tenant perform correctly? So it's not the agent's job to tell the tenant, but send the 20 days business notice. It's the tenant's, it's his rights in terms of the Consumer Protection Act. Yes, unfortunately, he was also in a bad situation, but the landlord was relying on him to pay. So arguably, you're probably looking at a claim against the tenant to say, that's fine, send the 20 days, but you do have to pay for the period where you blocked off the property, the 20 business days, possibly even a reasonable cancellation penalty, and then you're off the hook. No worries at all. Mother's a co-signatory. Sorry, mother, you did co-sign. No emotion attached. We sue for the rent that you owe. Agent, look, you could have dealt with this better. There was a little bit of time that was wasted because you as an agency didn't act as fast as you should or appropriately. Forget the debt. So now it's the agency. The agency could have done something, they didn't act. Maybe there's a little potential claim there. That's taking all the emotion, the swearing and all of it out. So if you look at pure civil legal liability, agency might carry a little bit, although small, because you really have to ask, what could the agent have done had he been alive? But I would still argue that, yeah, the tenant would still be responsible for the time of the lease up until the cancellation becomes valid.
I'll tell you what one of my arguments was, because I'm always trying to clutch at straws to help agents get out of these situations. And I'll just do it very quickly because I know you've got to run. My argument was that the lease, the mandate runs concurrently with the lease. The lease had now been cancelled. The mandate was at an end. So I believe that the agent could legally, or could at least say to the landlord, our mandate has come to an end. Unfortunately, our agent in that area has passed away. We're unable to offer the service anymore. You'd be best served by using another agency, but please get them to talk to us about moving dates, etc. So that was one of the solutions that I came up with. In the end,
That makes sense.
the mother did pay the money. I don't know if that's a valid argument, but I try and think of anything that sounds plausible. Because the mandate runs with the lease, and the lease had been terminated, in 20 business days, the mandate was going to be terminated. The agent said they would deal with the deposit issues, but that was my end. So
no,
it
look,
did get
yeah.
So
Look, the problem, yeah.
The mother
only
did
problem,
pay the rent.
Sure.
Sorry.
Sorry, no. So the only problem, obviously, with the termination of the lease, and that was my only concern, is that a level of small liability, obviously, it results from any damages that could have been suffered. So I agree with you. The lease, the mandate would have terminated if it ran concurrently with the lease agreement. Absolutely. Whether something could have been done faster to be aware that this tenant hadn't moved in and there was an issue and they hadn't received a deposit and they haven't received rental, because there could have been faster reaction. As an example, the tenant could have sent out a breach letter and started. So it depends on the timing. So if we actually sit down, we look at the timeframes and go, sure, 60 days went by and no one did anything, versus 10 days went by and no one did anything. If it was 10 days,
3 or 4 days.
No. But then there's no chance at all, because then it's barely anything. Then there'd be barely any damages because no one would have even noticed on a 3 or 4 days. So I would say that the agent's completely safe.
Fortunately, the mother co-signatory did pay the rent. So it all worked out well in the end. But of course, this was before that, and there was a lot of stress. The lady did say she doesn't want to deal with them anymore. But then she came back the next day. I said to them, grab on that and tell her she's cancelled your mandate in any case. And she came back the next day and said, no, she does want them to carry on. And they must find a new tenant. And they just did not want to deal. It wasn't actually the landlord, it was the landlord's mother that would grab the phone from the landlord every time they spoke to the landlord. And she was the one doing the shouting. I did want to get that one in there. Bruno, I know you've got to run. There were 1 or 2 questions, but I'll answer them. We should be fine.
No worries. So sorry about the noise in the background.
Say again?
No, sorry about the noise in the background.
I can't even hear noise in the background.
No worries, then.
Can I try and ask one quick question?
Let me just quickly check. So unfortunately, it's 10:02.
No,
so I do suspect that the person's here. But tell you what, if you send me the question over a voice note,
Yes.
I'll answer you back later today.
Okay, that'll be great. That'll be great. We do have 1 or 2, but that's absolutely fine. I will deal with them. Thank you so much.
Sorry about that. That was that was the person calling. But thanks so much, Sean.
No, that's absolutely fine. I knew. Thank you so much.
No.
It's everybody's raving about you. You're getting quite popular on here, so that's quite
Nice.
good. Thanks so much, Bruno.
Thanks so
Have a
much.
great day.
Have a good one. Thanks, thanks everyone.
Okay, cheers.
Bye.
So, ladies and gentlemen, there's one or two questions that unfortunately I couldn't get to. I do apologize to those that were involved. What I will do is I will send your questions to Bruno on a voice note, and I will come back to you on the answer. Some of them I can answer, I believe. So let's go back. Bruno thought that an hour for a Q&A was exceptionally long, but you know, with us and all our questions, it certainly isn't. I hope this has been useful. So I've got a question that says, what happens on a procurement? Tenant moves out on the lease expiry and we place a new tenant. Are we responsible for the outgoing inspection of the first tenant? This, Corinne, comes back to what your mandate says. My personal advice is to not include an outgoing inspection in a procurement. The relationship, the contractual, I like the idea that the contract comes to an end when you have done your ingoing inspection. I like to have the landlord do the key handover, because in the end, they didn't want to pay me to do a manage, but you must make sure that your procurement says exactly when it ends. I'll tell you why I don't like to do an outgoing inspection, because now the landlord will ask us to do an outgoing inspection, and then the landlord will try and get you involved to do the deposit disbursement and give them advice and all this stuff for free. We cannot work for free. And they will then say, yes, I had a case once where the landlord said, but that grass is dead. Do you think I've got a case here? I want them to do this. And I said, look, I'm sorry, I cannot get involved in your arguments. You decided to use me only for procurement. I gave that service to you. I cannot now get involved. If the landlord comes back to me for another procurement, at the very most, I will say, and they ask me to do the outgoing inspection, I will say, I will do the outgoing inspection and send you a report. But I will not get involved, because I don't know, because, you know, then it starts becoming, the tenant says, yes, but the landlord said they were going to do that. Yes, the landlord said I can do this, blah, blah, blah. We don't want to get involved in things that we're not getting paid for. So that would be my feedback on that. Then I've got another question. You know, one of the agents at our agency will take on any property. One of the property she manages has a roof which leaks badly. When a contractor went out, he told us the roof is not repairable. It needs to be replaced. It's not structurally sound and he would not live there. The owners are just ignoring it. The current tenant has given notice, and I've told the agent managing an uninhabitable property, but the agent feels that we have to accept the mandate. I agree with the person that has posed this question. You do not have to accept a mandate. This can cause you and your brand having reputational damage. I believe one needs to be at the point where one can say, I am very sorry. What I would do is I would go through the property or get the manager, in inverted commas. I used to do these things as the manager, go through the property and say to the landlord, thank you that you would like us to re-tenant your property for you. Unfortunately, we do have standards, and I'm not using the words right. You can word this nicely. The following will need to be done for this property to be acceptable for us to rent out. Once you've done that, we'll be more than happy to advertise. So throw it back in the landlord's court. You do not want to be known as the agency that deals with slum landlords. And I know I'm using words very, very loosely here, okay? But I'm just trying to get the message across. Then another question, what happens on on a procured lease, says this question, where the lease is on the agency's lease, what happens should the tenant not pay or where there are conduct issues? Is it the agent's responsibility or the landlord's responsibility to resolve, as it's an agency lease? I take this must be more specific in the lease. the fact that the agent was the procuring agent and the one who concluded the lease agreement was on the mandated authority of the landlord. Your procurement mandate must say very clearly that once this moves on, once that handover point comes from where you hand over to the landlord, which I normally like to think of after the ingoing inspection report, but before the key handover. So it sounds technical, but you know me, I'm only retentive. That at that point, the landlord takes over. So anything after that is the landlord's responsibility. The agent has fulfilled their requirement, but one would need to just check that your mandate is specific. But what I can say to you, there is a clause somewhere that says that as long let's just leave it at that. Sorry, I just want to wrap up here. If the landlord chooses not to renew their mandate due to the agency not fulfilling their commitments, the tenant stays on, but the landlord gets a new agency to continue to manage the lease. The landlord gave 2 months notice to coincide with the end of the mandate lease period. Is the commission still due to the initial agency? Lindsay, let's maybe just go back to the fundamentals here. So we've got a 12-month lease, which means that our mandate then becomes a 12-month mandate as soon as that lease is signed. Anybody, just like the landlord is the consumer, so the landlord can give legal notice at the end of that mandate period. So I would think if it's a fact of the agency not fulfilling their commitments, the normal process, if the agency does not fulfill their commitments, would be that the agency has breached, the supplier has breached, the consumer, being the landlord, can put the agency on notice and demand specific performance. So in other words, they can say to the agency, listen, you have breached your mandate by not doing the following things. I hereby give you 20 business days to correct that breach, failing which I can cancel the mandate. That would be the safe way to cancel that mandate. And then, of course, if the agency doesn't, so it's exactly the same. It comes back to the consumer supplier situation. I hope that makes sense. Sorry, I am trying to wrap up because I don't want to keep you here for too long. So that, ladies and gentlemen, I think brings us to a conclusion. I hope you had a great morning. And there were things that I had that I didn't get to. I apologize for that. I hope I've answered all of your questions. Okay, great. So we've got to remember that if the mandate becomes fixed term, then we've got Consumer Protection Act, the normal stuff, Section 14, all those sorts of things. So that would be the legal way for the landlord to cancel based on non-performance. Landlords, of course, do not have the knowledge we have, so they probably don't do that. But one of the things that does say in Section 14 is that you can cancel legally by giving the required notice before the end of that fixed term period. So I would say the landlord has cancelled legally, and I don't think that one would be able to claim that. And especially when it gets to poor performance, you don't really want to go, go public or have a public spat or end up on Hello Peter. We've got to manage reputation as well. So, ladies and gentlemen, thank you so much. Huge thanks once again to Bruno. For those, I was actually live streaming on Facebook as a test. So for those people who are on Facebook, this is the Rental Training Club training, which we do every month for our Rental Training Club members. If you're interested in becoming a Rental Training Club member, this is exclusive to Rental Training Club. I just thought I'd give you a sneak preview of what you're missing. Just WhatsApp us on 071 306 1202. 071 306 1202, and we can help you get into the Rental Training Club so that you get this sort of information and all this expert information and current happenings as we go on. So, ladies and gentlemen, thank you, Rental Training Club people. You will get a link to the recording as soon as it's available, and you will get your certificates of attendance with your CPD points. Those on Facebook, join the Rental Training Club, then you'll get all of those things too. So thank you, everybody. Thank you for your questions. It's been fun. Have a good day. And I can say have a good weekend. Remember, we do have rental application training tomorrow. The link is on Facebook, and I did share it. So if anybody wants to come to the rental application training, just go to my Facebook page, Rental Sphere, and you should be able to book for that. Other than that, have a good day and have a good weekend.